Marcus Green, a 38-year-old special education teacher from Brooklyn, was descending a rain-slicked staircase at the Atlantic Avenue Barclays Center subway station in January 2026 when his foot caught a broken, unanchored rubber stair nosing that the MTA's own maintenance logs showed had been flagged for repair 14 months earlier. Marcus fell 8 steps, 2 vertebrae fractured. He was told by the first attorney he called that the MTA had sovereign immunity and couldn't be sued. That attorney was wrong. And that wrong answer almost cost Marcus everything. Lying in a hospital bed at NYU Langone, Marcus kept hearing 2 things. You can't sue the government, and you only have 90 days. Both statements terrified him. He was a single father. His salary was his family's lifeline. Physical therapy would take 18 months. The MTA's claims department had already sent a boilerplate denial letter citing comparative negligence, suggesting Marcus should have been more careful in wet conditions. The word immunity was a door slamming in his face every time he looked for help. New York's Court of Claims Act, Section 10.3, and the New York City Transit Authority Act establish a specific notice and claim framework for suing transit authorities. Sovereign immunity does not bar these claims, but it does impose strict procedural tripwires. Under General Municipal Law, Section 50E, a notice of claim must be filed with the MTA within 90 days of the incident. Failure to file timely is nearly always fatal to the case. However, the substantive liability standard is well established. Under Friedman v. State of New York and its progeny, a transit authority can be held liable for dangerous conditions on its property if it had actual or constructive notice of the defect and failed to repair it within a reasonable time. The MTA's 14-month-old maintenance flagging record constitutes near-perfect proof of constructive notice. And in New York, that documentation is discoverable under CPLR Article 31. Marcus found a New York transit injury specialist who filed a notice of claim with the NYC Transit Authority on day 87, 3 days before the deadline. Through CPLR discovery, counsel subpoenaed the MTA's station condition reports, which documented the broken stair nosing under a priority to repair designation dated November 2024. A biomechanical engineer testified that the broken nosing created a 3/4-inch elevation differential, exceeding MTA design standards. Marcus settled before trial for $1.35 million, covering spinal fusion surgery, 18 months of lost wages, future adaptive equipment, and pain and suffering. The lesson: the MTA is not immune. It is simply protected by a 90-day clock that most injured New Yorkers never know is ticking.